Afternoon, everyone, and thank you for joining us. I'm Bushra Ali, proud to have you here on behalf of Equality, Diversity, Inclusion. Please do use the chat box to type in your questions, and both our speakers will be happy to take questions from the chat box once both speakers have presented. So without further ado, over to Naomi.
Thank you. Hello, everyone. As you know, I'm Naomi Hobbs from Number 8 Chambers. I'm a family practitioner and have been practicing in family law since 1993, which sounds like a very long time. I particularly specialise in care work, although I also do private law. And for this afternoon's purposes, I shall be speaking to you in particular about vulnerable witnesses and about AB interviews. Most of us, in fact all of us in the family jurisdiction, from time to time will have a vulnerable witness. And it seems to me that over the years, although there are special provisions for us to implement for vulnerable witnesses, from time to time those special provisions may go by the by, which essentially means that those witnesses are not getting a fair hearing. Can I start by referring to a case, and I'm sorry to dive into law so soon, but it's the case of Re-N, a child. It's a 2019 case, EWCA Civ 1997. And in that case, King LJ looked at the issues around effective participation of vulnerable witnesses and the challenges that they have, or the court will have, in effectively giving them a fair hearing. When King LJ considered the case of Re-N, she referred to another case. It's called Re-M. And in the case of Re-M, Thorpe LJ made this comment. Thorpe said, "I only observe that the general duty, and in brackets to achieve targets, cannot in circumstances override the duty to ensure that any litigant in her court receives a fair trial and is guaranteed what support is necessary to compensate for a disability." Now that is very relevant for today, because most of us will feel particularly under pressure to move cases along very quickly, because cases have been out of operation now for nearly 3 months. The courts are under pressure to get through a certain workload, and it will be at a cost, at a significant cost to vulnerable witnesses, were we to sweep under the carpet the provisions that have been clearly thought out to enable them to have a fair trial. Thorpe LJ commented about submissions made by counsel, and what Thorpe said was, his right to Article 6 protection is absolute, and as Mr. Storia, is a local solicitor, said, "We simply do not know how much better the father's evidence would have been in the witness box had he had the support which he was plainly entitled to." That was a comment made by Thorpe, and if we don't, as advocates, ensure that our clients have the best provisions, those clients will not, of course, be able to give their best evidence. We should also note that in the case of Re-M, the comments made by King was, in the 2 years following Re-M, the recognition of the need to ensure that vulnerable witnesses are in a position to give their best evidence gathered pace. And in the case of P versus Cheshire West, this observation was made by Lady Hale. Disability places upon the state and upon others the duty to make reasonable accommodation to cater for special needs of those with disabilities. McFarlane, in the case of Reece C, 2014 case, was clear that the court, as an organ of the state, the local authority and CAFCAS, must all function now within the terms of the Equality Act. It is simply not an option to fail to afford the right level of regard to an individual who has all these unfortunate disabilities, as the parent did in the case of Reece C. So as advocates, not only do we have regard to the regulations in terms of special measures, but we should also have an eye on the Equality Act of 2010. Then we note that Sir James Mumby actually, in his view from the President's Chamber, produced a document in June 2014, and he observed that there was a pressing need to address the wider issue of vulnerable people giving evidence in the family proceedings courts, something in which the family justice system has lagged behind, in fact lagged woefully behind the criminal justice system. And to that end, Sir James Mumby set up a vulnerable witness and children working group, and out of that there was a document which set out the protocol that should be followed so far as vulnerable witnesses are concerned. But it's interesting that this is possibly one of the first occasions that there was some serious consideration given to victims of domestic violence and witnesses in private law proceedings. And in considering those vulnerabilities, you know, whether or not a victim of domestic abuse could possibly be intimidated, whether or not they should have screens, whether or not there should be interveners, and whether or not they should have any special provisions also. All of those considerations were undertaken by the working group. They made recommendations as a result of their work, and those recommendations were encompassed in Practice Direction 3AA. And I'm not going to go through all of the recommendations that were made, but in bullet point form, the court must consider whether a party's participation in proceedings, other than by way of giving evidence, of course, is likely to be diminished by reasons of a vulnerability, and if so, whether or not it is necessary to make one or more participation directions. The court must consider, we all know, whether or not the quality of the evidence that is going to be given by that party or a witness is likely to be diminished by reasons of vulnerability, and if so, whether it's necessary to make one or more participation directions. Most of us will know that in order to obtain the special provisions, you would normally have some sort of assessment of your client, which would point out to the court or highlight the level of vulnerability and what special provisions there ought to be. There is also a duty placed upon the court, which has been established under Part 3A of the Practice Direction. Those duties apply equally to parties as to the court. And sorry, I'm referring to Part 3A of the practice guidance. It's also a duty of the court and all of the parties that are participating in the proceedings to identify any party or witness actually who is vulnerable, and that should be done at the early stages of the family proceedings. So essentially what that is saying is that in this climate where there are sometimes litigants in person, and it may even be the other party who has a client that is vulnerable, we all have a duty to point out those vulnerabilities to the court to ensure that that party has the appropriate provisions considered and put into place. Once those parties have been identified, the court then has a duty under Rule 3A.5 to consider whether to make participation directions. And where a court has decided that a vulnerable party or witness is to give evidence, it must then hold a ground rules hearing prior to the substantive hearing. And at the ground rules hearing, directions will be given as to the conduct of the hearing, the role of the advocates, the mode in which evidence is to be given, the topics for questioning, and the various other matters, all of which are set out in Practice Direction 3AA, subparagraph 5. What would normally happen is that advocates will perhaps by way of skeleton argument state what ground rules are being requested, whether or not, for example, there ought to be screens, whether or not there should be regular breaks, whether or not the witness should give evidence from a separate courtroom by video link, whether or not there should be other measures put in place to protect that vulnerable witness. Usually that is presented to the court by way of a written statement, skeleton argument, or a position statement. You would normally at that stage also have a report from an expert to say what the vulnerabilities are and to say how best those vulnerabilities should be catered for. I'm now going to move on to speaking to you about ABE interviews, and in fact interviewing children. There are basic principles that I'm sure we are all aware of when considering whether or not a child or children should give evidence, or in fact whether any vulnerable person should give evidence. And once the proceedings are on its way, it may well be that you should always have at the back of your mind the proposition that the court must analyse the allegations that have been made, for example, by a child, in light of the totality of the evidence. And I say that at this juncture because, of course, once you have an ABE interview, many courts put very heavy reliance upon the ABE interview without taking into account, for example, that the child may have made an inconsistent statement, perhaps to somebody at school, perhaps to a health visitor, perhaps to a friend of the family, or perhaps to a parent. So the inclination of the court to put a disproportionate amount of weight on the ABE interview should possibly be challenged if it's thought by an advocate that the court hasn't approached the evidence in a balanced way. The child or the vulnerable witness may have repeated or made repeated attempts to offer an alternative scenario or an alternative explanation to any allegations that have been made to different individuals, which were not repeated in the ABE interview. Obviously, a previous inconsistent statement would tend to undermine the veracity of any subsequent statements made in the ABE interview. The court must, of course, give all parties the opportunity to explore all of the explanations if possible. So, for example, if a child makes an allegation to a teacher and then makes a further allegation to somebody else and makes a retraction statement to a third party, it's very easy sometimes for that retraction or inconsistent statement to be lost in the melee of all of the evidence. It's our duty to ensure that or all of those inconsistent and varying statements are brought to the attention of the court, and for those witnesses to come to court if that is the right thing to do in the circumstances. It may be easy for a judge to say, no, I'm sorry, I can't have that witness, that is another child witness, and I don't want that child brought to court. But that child's account of what was told to her or him by the original complainant may be very important, and the application should be made. We shouldn't be fearful of making the application for fear of the application being rejected. The court should exercise a degree of caution in placing too much weight on an ABE interview, and the court should also consider what weight to be placed upon inconsistent statements, as we know. Looking then at interviews, there are some relevant statutory guidance so far as, for example, sexual abuse is concerned, and we all, I'm sure, have heard of the Cleveland Report. Now, I mention the Cleveland Report at this stage because many of us, even experienced advocates, will talk about disclosures that have been made by children. Yet in the Cleveland Report, we were cautioned against using the word disclosure, because when we use such a term, the possibility that whatever the child is saying may not be telling the truth. So rather than use the term disclosure, it's right that we should use an allegation rather than disclosure, because the term disclosure puts what the child is saying on a premise of truth rather than on the premise of alleging. Many people will have contact with the child prior to the ABE interview. For example, if the allegation is made at school or to a third party. And there is guidance set down by the government in terms of what duties are placed upon school officials, teachers, head teachers, in terms of what their duties are and how they should go about investigating what is being said by the child. And some of those guidelines are set out in a 2006 document. It's HM government. It's an HM government document which is dated March 2015, and it's called "Worried a Child is Being Abused." So that's an important document that if you have a case in which there are allegations of sexual abuse and the school has been involved in questioning a child, that's a document that you should look at in order to ascertain the level of inquiry or investigation that a teacher should be undertaking. Obviously, that third party agency will take the allegations seriously, and they will reassure the child that they will take action to keep them safe. Very often that statement is mistaken by professionals for meaning that they must believe the child. Children tell lies in the same way as adults tell lies, maybe not maliciously, maybe not out of a desire to be vindictive, but simply just because children sometimes are mistaken in their interpretation of something that may happen to them. So when you get a social worker giving evidence and inferring that the child should always be believed, I think that assertion ought to be challenged. When that third party is making their first preliminary investigation, they should begin by taking a detailed record of what the child is saying. They should be taking a brief record if possible. They are simply there to listen to what the child is saying, not necessarily to stop the child. The child should have a free recall of events, and where it is necessary to ask questions, they should be asking open questions or specific closed questions rather than a forced choice. And they shouldn't be asking multiple questions leading into other multiple questions. Obviously, that would be confusing. They should be clear about the purpose of why they're asking questions, whether or not they are trying to establish facts, or whether they are trying to ascertain whether or not the child has a therapeutic need. That's very important. Obviously, there should be proper recording of what the child is saying, and if possible, those notes should be contemporaneous, if possible. Social workers often go to see children once allegations are made, and there may be discussions, and when I say behind the scenes, I think you'll all know what I'm referring to. Whatever discussions take place, the professionals are charged with making sure that they keep a full and contemporaneous note of whatever is being said. If there is going to be a joint meeting with the police and social services, that meeting should be planned, and it should be planned in a way that they know something about the child before they go to such a meeting. They should have a broad outline of what has been said, and it's better, according to the Cleveland report, to have a delayed meeting rather than have a expedited meeting and to get everything wrong initially and spoil the evidence. So meetings, joint meetings in particular, should be planned. Going on to police interviews, that was my alarm going off because I think I've gone over time, but very quickly, going on to police interviews, obviously those interviews should be conducted according to the ABE guidelines, to which I've already referred. Clearly, the court will still have to make a judgment as to the veracity of any interview that a child has been has participated in, and perhaps not put all reliance upon what the child has said during the interview. The court should clearly see the video of the ABE interview so that the child's demeanour and the way that the child has answered the questions can be assessed to see whether or not the child was speaking spontaneously, whether or not the child was being prompted, and whether or not the veracity of what the child is saying can be relied upon. I think I've come to the end of that presentation, so I'll be prepared and happy to take questions once Mrs. Dhaliwal has done her presentation. Thank you, Bushra.
Thank you, Naomi. So, dear all, feel free to post your questions in the chat box, as Naomi has said. And then what we can do is that once Davinder has also completed her presentation, then both speakers can take a selection of those questions to read out and then to hopefully be in a position to answer them. So without further ado, if we move on to Davinder. Davinder, you okay to share your screen tonight?
Good afternoon, everyone. Thank you, Naomi, and thank you, Bushra, for inviting me. For those of you that I haven't met, I'm a family law barrister at number 8 Chambers. I've got a mixed practice of the full complement, I think they call it, public law, private children's law, and also financial remedy work. When I agreed to do the lecture about the impact of COVID-19 on both practice and procedure, I got lots of messages back from practitioners that we're now on day 86 of lockdown, but as family lawyers, our practices have changed so much that it feels like a former life. And to a certain extent, the message that I got back from other practitioners as to what they wanted to hear me talking about was that they flagged up the issue of what they do have is what can be described as information overload. So we have all the national guidance and roadmap, we have local guidance, we have relentless emails from our professional bodies, we're all keeping one eye on everything that's been shared by the Nuffield Family Justice Observatory, and we're kept up to date with what's happening at our local court centres, the risk assessments, the partial and safe opening of our courts for hybrid or attended hearings. So the request I had from individuals is that it wasn't necessarily the case law that they wanted me to speak about. It was really some shared experience of the realities of remote hearings, of hybrid hearings, effectively tips and practical guides for what we all call the new normal. And so what I did do, I'm just going to the bottom for all of you, is that I have, of course, done a case library, but I'm very conscious that those of you that are family lawyers know the sequence of cases. We know about the factors which we've got to consider for the right format of a hearing. And so what we're all experiencing now in remote hearings is that there is a balance to be struck between a fair hearing and avoiding delay. More so than ever, judges are exercising their case management powers robustly in a very focused way, and we're all looking for innovative solutions on how to hold those hearings. And so ultimately, it falls on judicial discretion as to the format of the hearing in light of the competing needs. But in my experience, the real emphasis is that all hearings are limited to those issues which are now necessary to determine. And so long gone are the days of where you took each and every point, you challenged each and every aspect of the evidence. This is really about relevance and focusing on what are the real issues. And so in general terms, when I went back to basics and looked around me at so many of the family lawyers, it's an area that they choose to enter. It's an area that they feel passionately about, and they've got a genuine conscience for the work. And right at the heart of that work is family reunification and helping families, children and adults at difficult times in their lives through various crises. What all of us enjoyed doing was going to court, as well as the intellectual challenge. there's the interaction aspect that, you know, we are all social animals. It's a sociable profession, and we all had a lot of professional and personal satisfaction in the old normal, because we did feel that we were making a difference in their lives. And so many of us do miss going to court. We miss speaking to our clients and our solicitors directly, and we miss other lawyers because we're very much a community. And so the reason I put this picture up was just a demonstration, apart from it being just aesthetically pretty, was to show the difficult task of communicating, but making sure that what we're doing in our remote hearings is effective. And so the real challenge is, from a professional point of view, in my experience, from the remote and hybrid hearings, is we're having to discover, learn, perfect a very different refined skill set in the use of e-bundles, so that we're able to download them, cross-reference, screen share with witnesses. And so there are very real technical challenges. And it's not about age. It's not set in stone that those of us that are a certain age find it more difficult, in my experience. But those of us that have been brought up for decades with sophisticated color coding schemes using different highlighters, different post-it notes, well, that's a thing of the past. We're all adapting to the new technology. It's telephone or remote video hearings. We are very accustomed now to Skype, Microsoft Teams, and certainly using Zoom from a personal experience for all the advocates meetings. And the court the court system is in a process where training is being given out to all the full-time judiciary on the CVP, the cloud video platform. What we're finding is that we need to use a lot of technology. You've got to have a screen, you've got to have another device for your bundle, your phone's got to be on, and so it's multitasking all of those. But in my experience, it's factor B, which has been the real challenge, because we are accustomed to going to court, taking instructions on the hoof. But the real difference now is that, in my experience, it's you just don't have the luxury of time. And so there's an expectation that even before you attend even an attended hearing, which I've done recently, there's no scope for conferences at court. That facility just isn't available as it was in the old days. And there's an expectation that all of that preliminary work, all the conferences have taken place and you're ready to go. What there is, in my experience, is a need to spend much longer in pre-hearing conferences with lay clients, because it's important that you set out all of the anticipated possible range of outcomes, because the court isn't always able to give you the luxury of time to take supplemental instructions during the hearing, especially if it's a time-limited directions hearing. And so whilst it's possible, as we used to, we would just turn around, have a chat with our client and say, do you want to add anything else? And so whilst it's possible to speak to our clients on WhatsApp, it's not perfect, because there are obvious difficulties when you have interpreters, lack of time, time pressures. And so it's very much focused, very much far more front loaded. I flagged up C hearing times because the judiciary, the court system, HMC courts, is under a huge time pressure. And so don't be surprised. You haven't said a word and you're tackled head on straight away at the beginning of the hearing. What are the real issues? And then it's focused, it's clear, it's robust. And so it is focusing minds as to dealing with things that perhaps we were used to at appellate level, where there's a quasi-inquisitorial aspect where you don't get a chance to set your stall out because there's an expectation that you've done that in bullet point D, which is advocacy, written submissions and skeleton arguments. And so we've all prided ourselves on our ability to make those powerful and persuasive oral submissions, but rising to the top of the list in my experience is the significance, more so now than ever, of written submissions and the importance of skeleton arguments sent in a timely manner. That just means send it in early because it's an essential part of judicial preparation. And so advocacy is still an important key skill, but it's a bit of a photo finish on, certainly on directions hearings, because it is all about the written word. And so bullet point E, there is a need for a more structured approach. It's got to be a little bit more focused than it ever was. And you've got to cherry pick a handful of your best points. And even if that means having to give your lay clients more realistic advice at an earlier stage about the potential outcomes. And so I flagged up 24/7 because in an age where we are all expected to protect our well-being, the reality is that we have all experience of emails after 6 p.m, sometimes at 10:30, sometimes just after midnight, and occasionally I get emails at 2 o'clock from other advocates. And so we're expected to protect our own well-being, but it's an impulse reaction to try and answer as soon as you receive. And so it's really a matter of personal preference. But I certainly discourage a flurry of emails during the night. G, requesting a break to take instructions. I flagged that up because of a personal experience. Just a week and a half ago, I did a telephone hearing, an appeal, which lasted 5.5 hours. And we only had a 15-minute break when one of the lay parties had to answer the door to a police officer had knocked on her door. And so we've got to be asking for breaks. And I know it's difficult because on that particular day, the last thing I wanted was that the hearing was adjourned. The judge didn't have time to complete it, or there's a risk of a hearing going part heard because of the cost impact on a privately paying client. And so please don't be shy about requesting a break, because if you do get a window of opportunity, you're more likely to be able to take instructions and save time in the long term. In my experience, what needs a little perfection at the moment is point H. All the hearings that I've had, remote hearings where there are interpreters, there is time made for the interpreter to translate, but it's within the hearing of everyone. And so what perhaps needs to happen is there needs to be a mechanism by which there can be a direct line of communication between the interpreter and the lay client, because we all know are very skilled interpreters that can interpret simultaneously, but it's important that there is a fair hearing, but it does add enormously to the time for a hearing. And I I flagged up, there are lots of resources available, which I can send to you about how to manage e-bundles, the various platforms that you can use. And so we're all getting used to those. That was professionally. I tried very hard to find an appropriate picture, but perhaps this sketch is a product of its time. But this is what we're all doing at the moment. We're all under a huge amount of pressure, legal, financial. We've all got the burden of childcare and some caring responsibilities. We're expected to be homeschooling, and there's a lot of uncertainty. And so I have been approached by lots of lawyers who are feeling a little bit despondent, which I'm sorry to hear, because for those of us that were so busy at one point, thinking, well, I've lost my sense of self. Well, they've had a little too much time on their hands, which hasn't been productive in terms of legally. And so it's important to keep in contact with your colleagues. It's important to have your WhatsApp groups. It's important to have a distraction, because they're not easy. It's not always easy to find a private room, a quiet area when you've got family members in the back popping in and out, particularly children with their gadgets and gaming and all the rest of it. And so it's not been an easy time, but I do focus on what I started at the beginning, which is that in my experience, family lawyers choose to practice family law because they have a very strong sense of conscience. And in the current climate, you'll all recognise that classic. Sometimes it's what's used for the slightly more mature practitioners as to what prompted them to go into law. But I just end on this note that what we do have is lawyers being very conscious of their role to ensure that there is a call out, there is a recognition of injustices, and that role is certainly going to continue. And as I said at the beginning, I have done all the relevant case law, but that wasn't what was requested from me. So I hope that's been helpful.
Thank you, Davinder. That is really, really helpful.
Well, thank you. I'll carry on with part B. I've tried to make it bite-sized and manageable. For those financial practitioners, some of this may be just a refresher course, but there have been a raft of important changes introduced by the, as I've set out, the Family Procedure Amendment Rules 2020, that's Statutory Instrument 2020-135. You've already probably had experience of some of those changes, because the initial changes came into force on the 6th of April this year, and the second tranche will come into effect on the 6th of July 2020. And so when legal advisors, since some legal advisors since the 6th of April are authorised to deal with certain items of correspondence and case management issues, and there is a very clear expectation that if you send a piece of correspondence into the court which involves a substantive issue, not administrative or an innocuous piece of communication, there is an expectation that the other side have got to be copied in. And so the language and the tone of this statutory instrument that I'll go through is very much in mandatory terms. And so it has been the case, or certainly the perception by the Financial Remedy Court, that unrealistic cases are taken to final hearing. And so the focus of these amendments is very much on costs. So there's a cost benefit analysis at a very early stage. And so the general rule, Family Proceedings Rule 28.3.5, was that the general rule was that in financial remedy proceedings, the court wouldn't make an order requiring the other party to pay costs. And so what you did have is applications proceeding, or sort of the perception that applications would proceed in the hope that the other side would either run out of energy or in fact money, and they wouldn't be a cost sanction unless, of course, and I've just gone over the page, the court's always had a power. So there's a general rule, but the court always had a power to make the other party pay the costs, the other side's costs. And so those cases where there's been litigation misconduct, the court has always had that power, where it considers at any stage of the proceedings, it considers it appropriate to do so because of the conduct of one party in relation to the proceedings, whether before or during. And so that can be disclosure, it can be expert evidence, or a raft of things. But it was always quite a high test, requiring a further, sometimes a freestanding hearing on the issue of costs. And so the changes now are very much on costs. And so from the 6th of July, Rule 9.271, at least the day before every appointment, there's got to be an estimate of the costs that have already been incurred. That's a new provision, as is bullet point 2, that a day, not less than a day before the first appointment or the financial dispute resolution appointment, there's got to be also an estimate of costs likely to be incurred to the next hearing. And so it's very much focusing on cost benefit analysis. And so if the court does eventually list the matter, all settlement proposals and negotiations don't work, then 9.274, at least 14 days before the final hearing, there's got to be served cost particulars. And so both historical costs incurred, but also costs likely to be incurred. And it's very clear, 9.27, 5 and 6, they've got to be served, those cost estimates, they've got to be brought to each hearing, and they've got to be served on the other party with confirmation, with a statement of truth, that those costs have been discussed with the client. And those costs estimates filed, 9.278, it's got to be recorded in the recital of the order, so there's no wriggle room at all about it being overlooked, because if it is overlooked, then 9.278 kicks in. They've got to file it subsequently within 3 days, actually within or any other time the court might specify. I'm sorry, there's a typing error. I've just watched a little typo there. And the non-compliance has got to be recorded in the recitals. And so it's very much about transparency, about costs incurred, about costs likely to be incurred in the future. The other significant amendment is that on the issue of open proposals, and so 21 days after an unsuccessful FDR or a date directed by the court, there's got to be the service of open proposals. And so the logic of the 28 days may be that it gives people a little bit of time for the dust to settle, to continue the negotiations when the settlement proposals haven't worked at the FDR. And also, if there's a category of cases where there's not been an FDR, which is, in my experience, pretty rare these days, then the open proposals still have to be filed within 42 days of the final hearing. And so if there's an unreasonable failure to make open proposals, we have Practice Direction 28A, paragraph 4.4, which is significant because, and I've flagged it up in blue, the court will take a broad view of conduct for the purposes of this rule and will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs. And this is called the bone shaker. This includes in a needs case where the applicant litigates unreasonably, resulting in costs incurred by each party becoming disproportionate to the award made by the court. And so the old argument, if it were ever a valid argument, well, I shouldn't pay costs because what it will have is dissipate the award that I've got and it's not capable of meeting my needs. Well, there's a change in the horizon. And also, when there's an order for costs at an interim stage, the court will not usually allow the resulting liability to go back on the balance sheet of matrimonial assets, on the matrimonial kitty, as I call it sometimes, of assets and liabilities. And so there are important and significant changes with a very clear focus on costs, but sharing that information on a cost-benefit analysis. So again, I hope that's been helpful for all those attending.
Thank you, Davinder. That is the last slide, is it?
It is.
Lovely, thank you. I'm just looking, right, there's no questions arising from that. So was there anything further that either you or Naomi wanted to say? I think I would just add there that number 8 chambers are open for business as usual. Feel free to contact Chris or Rose with respect to needing to instruct counsel. Perhaps Naomi and Davinder, if you could just say something about your specialisation. I mean, are you doing publicly funded work? Are you doing any urgent applications, private work, just so delegates do have an idea as to what kind of matters they could instruct you on, if that's okay?
Well, as you know, I do mainly public law, but also private law. I've been in the Court of Appeal twice this year, and I'm expecting another case in the Court of Appeal later on this year to do with the Satchel case that I was on a couple of years ago. I have previously worked in the immigration court, but that was some time ago. I know that Mrs. Dhaliwal also has a expertise in immigration work. I think that's all I want to say about myself, really. Yes, thank you, Bushra. Thank you for organising this afternoon.
Thank you. Davinder, did you want to say something about, because you're still doing immigration work as well as family, aren't you?
I'm certainly doing a small number of what I call niche cases where there's a public interest angle, or there's a real overlap between immigration and family work. And so I've got a mixed practice, so I do public law and I do private law and I do money work, which is still quite rare, but I've managed to juggle all of those. But certainly where there's an international aspect, and certainly some court of protection work, again, where there's a bit of an overlap between forced marriage protection orders and the court of protection. And so what we're all looking forward to is a little bit more stability, I think, in terms of a little more certainty in terms of what's happening with the court centres. We are already listing hybrid cases. I listed a hearing, I think, straddling September and October for a 10-day hearing, where we're going to have a ground rules hearing because there's lots of vulnerabilities, but also we just don't know how the land will lie on being able to return to court safely. So thank you again for asking both myself and Naomi.
Obviously, I don't know what the cultural dynamics are for all of your attendees, but if you are going to court, you're entitled to see the risk assessment that has been undertaken by any particular court that you're going to. I was in Worcester yesterday and they were very good. The court was immaculately clean, and actually the usher gave me a mask if I wanted to use one. But for all of those of us who are particularly vulnerable, you are entitled to see what risk assessments have been done, and you are entitled to enforce that risk assessment by contacting the court the day before and reaffirming that you expect everything to be complied with and making sure that they are complied with when you get to court the following day. Bushra, I just wanted to say that because I think it's important for our community.
No, Naomi, thank you for pointing that out. I certainly wasn't aware of that, so that is good to know. Thank you to all of the delegates that have obviously given up their evening this evening to take part in this. Please do aware there will be further sessions upcoming in relation to specialist subjects on immigration law and family law, and so hopefully the details will be released soon, and we look forward to seeing you soon. Thank you all, and thank you Naomi and Davinder once again, and thank you to Number 8 Chambers. Please do have a good evening all. Thank you.
Thank you everyone.
Bye.